Somebody's missing.
Oh, sorry, y'all. I forgot you.
Okay, you may be seated. Court is back in session and cause number 23 CCCR 0390. Case style of State of Texas versus Denair High. Let the record reflect that Mr. High is present in court with his attorney Marcus Wilkerson. State is present with Assistant District Attorney Haley Simmons sitting first chair, and Andrew Hibble, who's sitting second chair, and Shane Hilton, who's sitting third chair. Let the record also reflect that the jury is now present and seated in the courtroom. State, are you ready? Defense, are you ready?
Defense is ready, Your Honor.
Okay. Mr. Wilkerson, you may call your next witness.
Defense calls Officer Zachary Moss.
Zachary Moss. Officer Moss, would you please come forward? Officer Moss, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Officer Moss, you may put your hand down and you can take the witness stand. Is the mic on? Mr. Wilkerson, you may proceed.
Thank you, Your Honor. Good afternoon, Officer Moss. Appreciate you being here today. You just got back from, you were actually unavailable prior to today, right? You got in late last night. So I do thank you for being here today. I expect your testimony is going to be pretty quick. So do you have any recollection of taking a report made by the defendant Denair High in October of 2023?
Possible, what would that mean in reference to?
May I approach the witness, Your Honor?
Yes, ma'am.
Show you what for identification purposes only has been marked defense 1. Do you recognize that? Would you like to review it just very quickly? Does that reviewing that item help refresh your recollection about what I might be talking about?
Yes.
Can you tell the jury what the report was that you took from Mr. High on that day?
I believe Mr. High called in reference to, someone's like a road rage incident where, I can't remember who he named as the, basically, he was in the intersection of around East Lucas and Concord, whenever he had an issue with another driver on the road, and during that driver, pointed a firearm.
And did he tell you about any other past instances involving that same individual, or can you recall? Okay. And to be fair, it has been a year and a half since this occurred, right? And your report is pretty, or at least the incident report is pretty bare bones, accurate. But you do recall him making that report on that specific day. And at the time, were you working as an officer with the Beaumont Police Department? How long you been with BPD?
Now at the time, it's
At the time of the incident?
Less than a year,
Less than a year. How about now?
2 years and 2 months.
And you're certified peace officer?
Yes,
How long have you been?
2 years, 2 months.
Excellent. So you went straight to BPD out of the academy now?
So,
And where you been and are you still working a patrol?
I have, yes.
Have you changed departments since or?
I have not.
Okay, so you're still working patrol then?
Yeah.
And can you just briefly tell the jury about the training and education that you go through in order to become a peace officer and be a part of the Beaumont Police Force?
It started with the police academy, it's approximately 5 months long. Goes over various types of police work, code, health safety code, things like that. And then once we graduate that and meet the state requirements to be licensed, then we go through an approximate 6-month training program with the police department through field training.
And that training program with the police department, are you including in that? So you're talking about after you're certified by the state, then you go through further training with the department.
Correct.
And during that 6-month period, you typically ride along with partners. Is that accurate?
Correct.
Right. And then and that person kind of helps you and is supportive while you're handling calls and stops and things of that nature. Is that accurate?
Correct.
And then subsequent to that, you may still officially have a partner, but you are generally in your own vehicle. Is that accurate? But again, you did testify the distance in time, the attenuation in time with regard to this report that Mr. Hyde made. You don't recall who the actor was that Mr. Hyde had before you.
Correct.
Thank you, officer. Pass witness.
Ms. Simmons?
So you do recall taking a report from Mr. Hyde back in October of 2023. Do you recall anything of the person who he had accused?
I do not.
Do you know if it was male?
I believe he said it was male, but that's not as far as I could.
Let me ask you this. Do you recall ever responding to an assault on February 12th, 2023?
I do.
Do you even know who Daenerys High is?
I do remember from the report that I took in October, but that's.
Do you see him in this room today? Can you identify him by an article of clothing?
Pretty sure. But
This is the gentleman you talked to in reference to you claimed it was a road rage incident.
I believe so.
Was there anyone else you talked to on that road rage incident?
I believe I talked to a female that he might have had there, but she did not identify herself, didn't really wish to speak to me.
The female you spoke with, was that the person he was accusing of the road rage incident?
No.
Are you almost certain it was a male he was accusing of a road rage incident?
I believe it was.
You never responded to any type of assault on February 12th, 2023?
I can't.
Okay, no further questions for this witness, Your Honor.
Okay. Mr.
I have no
Wilkerson?
more questions, Your Honor. The witness be excused.
State.
Yes, Your Honor.
Okay. Okay, Officer Moss, you are excused, and just for the record, the rule has been invoked, and you know that you cannot talk to any other witnesses or anyone else about the case except the attorneys. If you violate this rule, you can be held in contempt of court. You're free to go, and you have a blessed day. Mr. Wilkerson?
Your Honor, my understanding that our last witness is unavailable and won't be available until next week, so at this time, the defense rests.
Okay. Ladies and gentlemen, state, do you have a rebuttal? Okay. Ladies and gentlemen, the state and the defense have rested their cases. And so therefore, we have to have what is called a charge conference. It's gonna take us a few minutes to go over the charge. And once that is done, we will bring you back into the courtroom for reading of the charge and the closing arguments. And then you will get the case and deliberate. Okay? So at this time, would you please stand? And you can exit the courtroom. You may be seated. Oops, let me turn this to on.
It's gonna be.
You may be seated. Let the record reflect the attorneys for the state, the attorney for the defendant, and the defendant are present in the courtroom. All members of the jury are present and seated in the courtroom. At this time, ladies and gentlemen, I will read to you the charge of the court. Members of the jury, the defendant, Denair High, stands charged by information with the offense of assault family violence alleged to have been committed in Jefferson County, Texas, on or about the 12th day of February 2023. To this charge, the defendant has entered a plea of not guilty. I now give you the law that applies to this case. Our law provides that a person commits the offense of assault, family violence, if the person intentionally, knowingly, or recklessly caused bodily injury to another, and the person injured is a member of the defendant's family or household, or with whom they've had a dating relationship. A person acts knowingly or with knowledge with respect to the result of his conduct when he is aware that the conduct is reasonably certain to cause the result. A person acts recklessly or is reckless with respect to the result of his conduct when he is aware, but consciously disregards a substantial or an unjustifiable risk that the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all circumstances as viewed from the actor's standpoint. Family includes individuals related by consanguinity or affinity as determined under section 573.022 and 573.024 of the Government Code. Individuals who are former spouses of each other, individuals who are parents of the same child without regard to marriage, and a foster child or foster parent without regard to whether those individuals reside together. Dating violence under section 71.0021 Family Code means an act other than a defensive measure to protect oneself by an actor that, one, is committed against a victim or applicant for a protective order, A, with whom the actor has or has had a dating relationship, or B, because of the victim's or applicant's marriage to a dating relationship with an individual with whom the actor is or has been in a dating relationship or marriage. And two, is intended to result in physical harm, bodily injury, assault, or sexual assault, or that is a threat that reasonably places the victim in fear of imminent physical harm, bodily injury, assault, or sexual assault. B, for purposes of this title, dating relationship means a relationship between individuals who have or have had a continuing relationship of a romantic or intimate nature, The existence of such relationships shall be determined based on consideration of one, the length of the relationship, two, the nature of the relationship, and three, the frequency and type of interaction between the persons involved in the relationship. A casual acquaintanceship or ordinary fraternization in a business or social context does not constitute a dating relationship under Section B. Therefore, if you believe from the evidence beyond a reasonable doubt that the defendant Denair Hyde did in Jefferson County, Texas, on or about the 12th day of February of 2023, did then and there intentionally and knowingly, recklessly cause bodily injury to another, namely Victoria Senegal, hereafter styled the complainant by grabbing the complainant by the neck with his hands, and at the time of said assault, the complainant was a person with whom the defendant was in a dating relationship, you will find the defendant guilty. Unless you so find beyond a reasonable doubt, or if you have reasonable doubt thereof, you will find the defendant not guilty. General instructions. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at the trial. The law does not require a defendant to prove innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant, unless the jurors are satisfied beyond the reasonable doubt of the person's or of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant's guilt, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution excludes all reasonable doubt concerning the defendant's guilt. You have a right to consider all the facts that are shown by the evidence and to draw natural and reasonable inferences from such facts. You alone have the authority and duty to determine what the facts are. In evaluating the evidence, you must totally disregard what you believe is my opinion about any factual matter. You cannot question the bailiff concerning the testimony or the law, nor should you discuss the case in her presence. If any question develops during your deliberation, it must be reduced in writing or reduced to writing, signed by your foreperson and given to the bailiff. The question will then be answered by the court as soon as possible to the extent allowed by the law. Questions and comments of the attorneys do not constitute testimony and must not be considered as evidence. You must also disregard any statement of the attorneys that is inconsistent with the law contained in this charge. Any physical exhibits admitted into evidence will be furnished to you by the bailiff upon your request. You must not consider facts that have not been introduced into evidence or legal principles not contained in this charge. It is improper for you to discuss or consider anything which you know or have learned outside of the testimony presented to you and the law contained in this charge. If you should discover that you have any outside information, you should not mention this information to any other juror, nor consider it yourself in arriving at a verdict. Our law provides that a defendant may testify on their own behalf if he elects to do so. This, however, is a privilege accorded a defendant, and in the event he elects not to testify, that fact cannot be taken as a circumstance against him. In this case, the defendant has elected not to testify, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations, or take it into considerations for any purpose whatsoever as a circumstance against the defendant. You are the exclusive judges of the facts proven, the believability of the witnesses, the weight to be given their testimony. However, you must be bound by and strictly follow the law contained in this charge. Your failure to follow the law could result in a mistrial being declared, and your deliberate violation of this charge could subject you to being held in contempt of court. After the attorneys present their arguments, you will retire, select a foreperson, and consider your verdict. The arguments are not evidence, and you should give the arguments only the consideration you feel they deserve during the evaluation of the evidence. It is the duty of your foreperson to make certain that your deliberations are conducted in accordance with this charge. After you have reached a unanimous decision, your foreperson should sign the appropriate verdict page attached to the charge. In returning your verdict, it is your responsibility to make certain that justice is done in this case. The last page of the charge is the verdict form. It has two sections. The top section states that we, the jury, find the defendant not guilty as charged in the information of assault family violence. If that is your verdict, then your foreperson will sign on this top line. Or the bottom portion states, we, the jury, find the defendant guilty as charged in the information of assault family violence. If that is your verdict, then your foreperson will sign on the bottom line. Does everyone understand? Okay. State, are you ready? Defense, are you ready?
Yes.
Okay. Mr. Wilkerson, you have 15 minutes, and I'll be keeping the time.
Thank you, Your Honor.
Okay.
Good afternoon, ladies and gentlemen. I want to thank y'all again for being here, obviously, for listening intently to the facts of this case that's been presented. I told y'all in the beginning, if this case were wrapped up in a neat little bubble, like the state's attorney conveyed to you, that it would be an easy decision. In my opinion, it's not that neat. It's not clear. I mean, what do you have? Right? What is the state relying on for their case? The testimony of the alleged victim, right? Now, you were asked who chooses who's present when these types of things happen, right? The answer that was given to you by the state, the defendant. Except there were two people present who would have been able to testify about these allegations. Two kids, right? Two kids who would have been able to testify, who were forensically interviewed in this case, who could have been brought to court, but they weren't. They weren't showing a woman standing up to an alleged abuser. They were kept at home. Didn't want to put them on the stand. Didn't want to put them through that. Why? Because they would have had to lie for it. I mean, that's what makes sense. You got a defendant, Daenerys High, with an impeccable record of civil service. Man works for the Bureau of Prisons, never had an incident, deals with violent criminals all the time, never had an incident. You've got Mr. High making police reports regarding the children's father, who, by the way, I want you to really think about this. You hear the complaining witness in this case testify that Mr. Hyde triggered Mr. Grant. And then what did she say triggered? He went to the birthday party of one of the kids who is living with him at the time. That was the triggering event. And that's why she wanted to protect the kid's father from prosecution. That's why she refused to provide the evidence regarding those threats to Mr. Hyde so that he could turn him over to law enforcement. For going to the birthday party of a kid that lives with him. What sense does that make? In this world, in the world where you're tasked with convicting a man of assaulting a woman based solely on the testimony of a victim, alleged victim, who gave up her credibility in front of you. Remember when I first started questioning her, asked her about what she alleged, talked about whether or not the defendant hit her or struck her or punched her. She said, oh, yes, I did. I told the officer that. Yeah, I told the officer he hit me. That's what she wants you. She wanted y'all to believe this man struck her, hit her, right? It was only after y'all were excused for a moment and we could give her some evidence of what was said that she admitted to you, oh, yeah, I did say he only grabbed me. She gave up her credibility. I didn't take it from her. She gave it up right here. She lost it in front of y'all, knowingly lying on the witness stand, knowingly lying to embellish the allegations against the defendant so that you would be more likely to convict him based on a sobbing alleged victim, right? The more serious the allegations, the more she can pump it up. The more extreme she can make it, the more likely y'all are to say, this man did this, right? This man treated this woman horribly. This man deserves to be convicted for assault causing family violence, assault causing bodily injury to somebody he's in a dating relationship with. Now, I told you in the beginning, I don't necessarily agree with how the parents became involved in these volatile situations between the defendant and the complaining witness. But what I can tell you is that every step of the way, Mr. Hyde, in all instances, you heard the officer talk about him making the police report for the terroristic threat issue, right? You heard the witness testify. At first, she told y'all she didn't know when she went back, right? And then when I confronted her with a picture, she said, oh, yes, that's my best friend's truck. I was there the day after the incident. Waited, officers didn't come in time, so I left. Said she didn't break the window. Want y'all to believe that's just a coincidence. I can't prove she broke it. So let's just call it an amazing coincidence that the day after these allegations, she's there. She admits she's there when confronted with evidence of having been there, not before. Remember, she couldn't remember when she went back, right? And then the window is broken, and does Mr. Hyde pursue her? No, somebody had to take a picture of her friend's truck being there. Does he pursue her? Does he go after her? No. What does he do? He calls law enforcement. That's what he does, because he deals with things legally. He deals with things in the only manner he knows how, through the proper channels. The state could have presented witnesses who allegedly would have corroborated what the victim was saying, but they chose not to at the victim's request. And every time I say that, right? Victim implies that he did this. Every word of this is intended to influence you to convict this man sitting right here. The very fact that the state goes first and last, that the last people you will hear from today are the prosecutors. Every bit of it, the awesome power of the state. Mr. Hyde has lived in the shadow of these allegations since February of 2023. 2 years he has lived under the shadow of these allegations. Ladies and gentlemen, several of you have kids. So I want you to think, when you're weighing the evidence and the credibility in this case, I want you to think, if it was your kid who was on trial here today, has the state given you enough evidence that you could say, well, you deserve to be convicted of that? They proved that you did that. You deserve to be convicted of that. Shame on you, right? If it was your kid, do you feel that way? Do you feel that evidence is that strong? Because the defendant is somebody's kid too. You know? Got to look at things through the prism of, I'm appealing to your notions of true justice, right? You swore an oath to follow the law. Following the law includes evaluating the statements of the witnesses that you heard from, judging their credibility. She said that she went to this friend's house after she left, after Daenerys supposedly grabbed her for the face. Why did he grab her by the face? Remember this? She wants y'all to believe that it happened because she didn't tell him the food was ready early enough. He alleges she broke her window. He didn't chase her down and beat her up for that. But he grabbed her by the face because she told him too late that the food was ready. Does that make sense? Does it fit together? The puzzle pieces don't match, ladies and gentlemen. And all I can do is try and point out these inconsistencies to you and ask you not to check your common sense at that door, right? You see the defendant sitting here. You heard the witness's testimony. You heard a mom say that, yeah, she sees the same rage in her daughter that she had when she was younger. You heard a mom say, yes, I've watched my daughter have a violent temper, right? Mom wants to protect daughter, wants to support her and everything. Completely understandable, right? Dad took the stand, wants to support daughter, wants to lift daughter up, wants to protect daughter under all circumstances. Good for him. Good for being a great parent. But his testimony didn't even comport with his daughter's testimony, much less his ex-wife's testimony, the mother of Victoria Senegal. His statements didn't comport with either one of their testimony. So, does that make him more or less credible? You see, it's not our job to drag her kids up here, put them on the witness stand, testify to you that he didn't do this, they didn't see it happen. That's not our job. It's not our job to drag any witness up here. We chose to put on a case to you to the extent we did so that you could understand the context in which these allegations are made. But it is the state's job to prove their case. It's the state's job when they tell you, well, only the people who were there could have witnessed it. Okay, so you've got more than just the defendant and the complaining witness there. Those people aren't here to testify about it. They're not going to take the stand and tell you that they saw what the complaining witness is alleging happened, what the complaining witness is alleging Mr. Hyde did to her, because they didn't. They didn't see that. So what do? At the end of the day, right? Weigh the evidence, shine a light on this shadow that this defendant has been living in for the past 2 years. Shine a bright light on him. Get rid of that shadow. Find him not guilty. Do the right thing here. Find him not guilty because of the discrepancies in the testimony of the complaining witness, the only witness who's making the allegations against Mr. Hyde. It just doesn't make sense. The whole offense doesn't make sense. Was the relationship toxic? Absolutely. It had become toxic. Is it best for everybody that it's over? Absolutely, it is. Absolutely. But you know what? Being in a toxic relationship or trying to bring parents into domestic disputes, those aren't reasons to convict somebody of assault. And so, if you decide to convict Mr. Hyde of assault regarding family violence, there will be repercussions far beyond a simple conviction. But if you do what's right, if you weigh the testimony, if you weigh the evidence, if you find the complaining witness not credible, and you find the defendant not guilty, then we can all do what her father allegedly told them to do regarding this Jordan Grant guy. Move past the past relationships, get it in the rearview mirror, get it all behind us, go our separate ways, and we can be done with this mess once for all. Thank y'all for listening to the evidence. Whatever the outcome, I truly appreciate you serving on this jury and listening intently as you have these past 3 afternoons.
Ms. Simmons?
Will you please report?
Yes.
Good afternoon. You know, the defense attorney was absolutely correct in stating that this was a messy case. And it's probably because the defense attorney got up here and went on unrelated tangents and forgot what we were actually here for. I submit to you, I've met my burden. And I want to go into the elements and I want to talk to you about February 12th, 2023. And that is in Jefferson County, Texas. The defendant, Denair Hyde, did then and there intentionally, knowingly, or recklessly caused bodily injury to the victim. And I want to specify victim because that is exactly what she is. He's claiming nothing happened. This was all just a figment of somebody's imagination. Let's take a look at these. Does this look like nothing happened to you? This is why we're here. He wants to go off on tangents that the state didn't produce the kids. You saw Cross yesterday with Victoria. That did not look pleasant. Could you imagine 2 children that were 5 and 7 years old at the time coming and having to deal with that? Like he said, some of you are parents. Would you want your children to have to go through that? He's arguing and he's telling you that we should do what Daryl said and stay out of this. We really want to bring the kids up. Victoria came up here 2 years later to face her abuser, a man that she had trusted, a man that she had loved, a man that she trusted enough to move into the home with her kids, only to be violated. That trust was violated. But let's get into that. We know there was arguments all day on February 12th, 2023. We know the relationship was toxic. Does that make it okay to put your hands on somebody and cause these marks? The scratching on the face, the bloody lip, the bruising on the neck? You heard her testify to the pain. You heard her testify that her children were screaming and scared. She had to unlock the window, guys. She didn't know how she was going to get out of the house that night. She got out. At what cost? Pushed out the door, shoved out the door, children falling. Doesn't even have her car keys. Her car keys are thrown to her. And then she is followed by that same abuser. Ladies and gentlemen of the jury, I would suggest and submit to you that he wanted control. Why else would he be calling dad every single argument? There's a cycle of abuse and control falls within that. Let's not forget that, of course, she went to a friend's house. People respond to trauma differently. It's been 2 years. Do we expect her to get up here and testify to verbatim? She's like plain, what is your guy? She doesn't know the legal jargon. She's testifying to facts that happened 2 years ago to her. She still has to live with. He's telling you that the defendant has had to live under the shadow of these allegations for 2 years. I submit to you, my victim has waited 2 years to tell you her side of the story. And she came up here and she did that. You heard it yesterday. Officer Hodges reported to the scene at her father's house that night. He testified to seeing the injuries. You can ask for these. You can go to the back when you go back and deliberate. You can look at these injuries. I ask that you do. Take a look at them. Look at the marks on the neck, the bloody lip. All the injuries are right here. Officer Hodges saw himself. That's not his daughter. He keeps arguing. Defense counsel keeps arguing that, of course, mother and father would want to protect their child, and of course they would. What interest did the officer have in this? He responded to an assault that happened on February 12th, 2023, at the hands of Denair on a woman that loved and trusted him. I submit to you, ladies and gentlemen, that I have met my burden. I think looking at the evidence, and as the charge will say, and you'll have that, questions and statements by the attorneys are not evidence. But the testimony of the witnesses absolutely is. Think long and hard. You have been drugged down tangents of irrelevant scenarios. We're not here for the kid's father. We're here for Victoria and ensuring that she gets justice. Absolutely, there will be consequences if you find him guilty. Hold him accountable. And when you go back there and you deliberate and you come to a unanimous decision, I ask that you find the defendant guilty of assault family violence. Thank you so much for your attention in this matter. I truly appreciate y'all paying attention for these past several days and the patience y'all have. Thank you.
Okay, ladies and gentlemen. At this time, the defense has made their closing arguments. The state has made a closing argument. And so you will retire to the jury room to deliberate. But before we do that, I must inform you that in a criminal case, a misdemeanor criminal case, there are 6 jurors. If you notice, there's 7 here. And the reason why there's 7 is because one person is an alternate. And the alternate is not allowed to go back into the jury room. The alternate has to stand by in case something happens to one of the other jurors, and then the alternate will come and stand in their place. Now, the alternate in this case is Catherine Louise Woolford. That's you? Okay. So, Ms. Woolford, you could either remain in the courtroom, or if you want to go out into the hallway as the other 6 members deliberate, you can do that. So at this time, I'm going to hand the charge to the bailiff, and remaining jurors will follow the bailiff into the jury room. Everyone, please stand. At this time, the court will be in recess until the jury reaches a verdict. Court is back in session and calls number 23 CCCR 0390. Case of style of state of Texas versus Denier High. Let the record reflect that Mr. High is present in the courtroom with his attorney. State is present with assistant criminal district attorneys. Let the record also reflect that the jury is not present in the courtroom. However, I have received a message from the jury that it has reached a verdict. Will the bailiff please bring the jury into the courtroom? You may be seated. Let the record reflect that the attorney for the state, the attorney for the defendant, and the defendant is now present in the courtroom, and the jury is now present in the courtroom. Four-person? Who's the four-person?
Oh, four, that's me.
Okay.
I thought you said floor.
No. Four-person. Have you reached a verdict in this case?
Yes, we can.
Is this verdict unanimous? That is one that is agreed upon by all the jurors?
100%.
Okay. Please hand the verdict form, well, please hand the verdict to the bailiff. Okay. And let's see. Four-person, is the verdict the unanimous verdict of all members of the jury?
Absolutely, 100%.
Okay.
No withdrawals, no questions.
Okay. Now, at this time, I'll read the verdict. And it says, we, the jury, find the defendant not guilty as charged in the information of assault family violence. Does anyone like the jury to be polled?
Not here.
No, Your Honor.
Okay.
Not to make a comment?
Okay. Now, at this time, you may be seated. At this time, Mr. High, you've been acquitted of these charges. We'll have a copy of this judgment in a few minutes. But at this time, I'd like to say to the members of the jury, first of all, I'd like to thank each and every one of you, including the alternate and everyone who has been served as a juror in this case. On behalf of the citizens of Jefferson County, behalf of the staff here in County Court at Law Number 2, we'd like to thank you for taking time out from your busy schedules to serve as jurors in this case. I do know that you were paying attention. I'm sure the state as well as the defense appreciated that. And the state of the defense may want to talk to you afterwards. You can talk to them if you desire to. If you do not want to talk to either party, you don't have to talk to them. Now, as I mentioned earlier to the members who are on the panel, anytime that you're in this area, you can have a seat in County Court at Law Number 2. And as I mentioned to you earlier, I know that when you came to court on Monday and you saw Terrence L. Holmes as presiding judge, you see I'm in the right court. This is Judge Holmes' court. But as I mentioned to you on Monday, this is not my court. This is your court because this court belongs to the citizens of Jefferson County. I'm only a humble servant serving the citizens of Jefferson County. So anytime that you're in this area, you can have a seat in that area. We call it the peanut gallery, but you can't bring peanuts in here and eat because this is not the Texas Roadhouse. And now your service is concluded. Before you leave, I usually give everyone a handshake, but we still have COVID, norovirus, and some other things in our community. However, I would like to give each and every one of you an air handshake. And thank you for being here. The bailiff has some letters for you. If you would like to drop a line, you can do that. At this time, your services are over. And again, thank you for taking time out from your busy schedule. Okay? All right.
Oh.